Thank you very much. So, of course, the Trans-Pacific Partnership is a major international trade initiative in which Canada is involved. The text of the agreement was signed in February 2016, and as the federal government likes to say, it's one of the most important trade agreements ever negotiated. It involves 12 countries spread out around the Pacific Rim, which together constitute about 40% of global trade, and includes 3 of Canada's 5 largest trading partners, of course the United States and Mexico, but also Japan. But the agreement is much broader than just a trade agreement, and we're very fortunate to have an excellent panel here today that are going to talk about some of the other areas that are addressed in the agreement, in particular the intellectual property rights provisions. And part of the focus of a number of the presentations will be on the health implications of those provisions. So I think, of course, a very important matter of public policy in every country and certainly in Canada. So what I'm going to do now is I'm going to briefly introduce each member of the panel. I think I'll introduce all of them at the outset, and then they'll each give their presentations, and I hope we'll have lots of time towards the end for you to ask your questions or make your observations about these issues. Okay, well, I'll introduce them in the order in which they're going to speak. So we're going to start with Dr. Tana Del Campo, who is an adjunct professor here in the Common Law section. She also holds positions as a research associate at Oxford and Cambridge. She has a doctorate in law from Cambridge, as well as a master's in international law from the University of São Paulo in Brazil. And next to her is a figure who's well known to those of us in the law school community, Dr. Michael Geist, who is the Canada Research Chair in Internet and e-commerce. And he's a very frequent commentator on intellectual property rights issues, particularly privacy issues, and he's written a number of things, both popular pieces and more scholarly pieces dealing with the TPP. I think he's actually going to talk about the CETA today. But okay. Next to him is Dr. Marc-André Gagnon, who is a political economist with the School of Public Policy and Administration at Carleton University. He's currently a visitor here at our Center for Health Law, Medicine and Ethics, and he has a PhD from York University and a master's degree in Advanced Economic Studies from the Université de Paris at Sorbonne. And finally, we have Ron Labonte, who's actually sitting in the audience over here because he's so interested in what's going to be presented before he gets a chance to talk. He wants to make sure he can see it in terms of the presentations and the slides which will be used. And Ron is also perhaps well known to many of you in this room. He's the Canada Research Chair, a Tier 1 chair in globalization and health equity. For more than 20 years, he's been a leading commentator on the equity implications of globalization, including globalization through international trade and investment agreements like the TPP. So we have an excellent panel, and I'm very much looking forward to hearing what they have to say. Now, what I've asked each of the panelists to do is limit their remarks to 10 minutes. I'm going to try to be rigorous and indeed brutal in enforcing the 10-minute limitation, and that will leave us lots of time, I think, at the end to have an open discussion about these important issues. So with that, I'll turn everything over to our first speaker, Dr. Del Campo.
I think we blocked access to food, so I'll just unblock the access.
Good morning. Thank you for inviting me to speak today. I would like to especially thank Gallo for the work that she has done to put this event together. So thank you, Gallo. Well, I was asked to open this panel and give an introduction to the topic of intellectual property and health, to give a bit of a background to the more specific questions on the TPP that my co-panelists will bring. So I'll talk about IP, especially when it comes to the patent system and its implications on public health in the first part of my presentation, and then look at the TPP and its IP provisions and discuss some ethical considerations related to its potential impacts on public health. I was also asked to talk from the perspective of ethics, given that health law and ethics is my area of expertise. So my goal here is to highlight some ethical considerations on what is at stake in the TPP, given this ethical background. Okay, but before I do this, I want to clarify here why ethics matter in a debate like this and in debates in global health in general. And to explain this, I'll tell you a personal story of how I got interested in ethics. Years ago, I worked for the UN Office for the High Commissioner for Human Rights in Geneva. And I was present in many treaty negotiations. And it was clear, governments, UN experts, NGO, human rights experts in general, they all agree that we all share a responsibility for global health problems. And they all agree with this general idea, but they could not agree with the specificities of the concepts. So they didn't agree on what responsibility means, how much responsibility each global stakeholder should have. They couldn't agree on what is health, what is well-being, what is the right to health, or even what is global health. In short, I realized during my time in Geneva that what was missing was not political will. We all want to collaborate and to solve collective problems like those problems in public health. What is missing, however, is conceptual clarity, because decision makers often use concepts that are overly broad and underspecified, like everybody has a responsibility to tackle global health problems. But what does that actually mean? What we need is a clear and nuanced understanding of what is at stake. And that's why ethics is crucial in legal and political debates. Ethics help us to identify the conceptual common ground on which we can all agree so that we can move the debates and negotiations forward. So this is my task here today, clarifying the concepts that are at stake in the debates on IP, patents, and access to medicines, so that we may be closer to reaching common ground when debating TPP. The first concept at stake in this debate is intellectual property. Okay, so first, what is intellectual property? IP is globally regulated by the World Trade Organization through the TRIPS agreement. And the IP system has two main purposes: compensation and incentives. Innovators should be reasonably and fairly compensated so to recoup research and development costs. And medical research and development is particularly costly, lengthy, complex, and uncertain. So justice requires that medical innovators be compensated for their diligent and successful scientific efforts. And on top of compensation, IP rights also give an incentive to foster more innovation and foster scientific progress. These are the two purposes of the IP international system. But interestingly enough, they are also the two premises that constrain, that limit the IP international system. These two premises set the boundaries delineating IP rights, and it's unjust to go beyond them. So the TRIPS system not only established the right of innovators to receive compensation and incentives, the TRIPS also established a duty not to abuse intellectual property rights. And the TRIPS system does so explicitly in the area of public health. The Doha Declaration clarifies and reinforces that the TRIPS agreement does not and should not prevent WTO members from taking measures to protect public health. And this is why the Doha Declaration clarifies and reinforces the relevance of Articles 30 and 31 of the TRIPS, which present the exceptions and limitations to intellectual property rights, which specifically when it comes to problems of access to medicines and access to medical knowledge, which are crucial for controlling and for solving public health emergencies. So these are the reasonable justifications for and the limitations of the intellectual property system. And this is the common ground on which all WTO members agree. Now, if these are the reasonable justifications for and limitations of the TRIPS system, and number two, if the TPP derives from the TRIPS system, then the logical conclusion is that the TPP should also have the same justifications and limitations when it comes to its chapter on patents. But does it? Does the TPP respect and endorse the patent limitations that the TRIPS agreement stipulates? Well, if we look at the letter of the law, the IP chapter in the TPP actually affirms several times TPP's commitment to access to medicine by respecting and not preventing each party from taking the necessary measures to protect public health, and by affirming also that each party has the right to define what a public health crisis means in their particular context. Article 18 in the TPP even includes examples where this should be especially the case, citing public health crisis in cases of HIV/AIDS, malaria, TB, and other epidemics. So here, the letter of the law is actually aligned with what a reasonable and fair patent rights system should look like. But what about the reality? Good ethics depends on good facts of reality. Does the TPP provide, in actuality, reasonable and fair compensation and incentives, or does it go beyond and violate the duty not to abuse intellectual property rights? There is an indication, there are several indications that TPP does abuse it, and there is also indication that the parties, especially the developed countries, there are parties in the TPP, are not taking into serious considerations the negative implications that an extension of the patent term could potentially have upon 4 TPP parties that are not as developed as the others. And these are Malaysia, Mexico, Peru, and Vietnam. So although the TPP does give them a longer period to incorporate TPP's provision, it doesn't provide a clear and nuanced enough provisions and exceptions to really protect public health, especially in these 4 countries. So to conclude, there's here a general ethical duty not to abuse the intellectual property rights system. And in the case of the TPP, there is also at least one specific ethical duty, which is parties should have, they have an ethical duty to more clearly define specific public health safeguards for those 4 countries so that this trade agreement may benefit its 12 parties more fairly. And there is also an ethical duty to more clearly define specific public health safeguards for other developing countries. They're not parties in the TPP, but that may have their public health impacted by the TPP. Thank you.
Great. Well, thanks very much for the invitation. My congratulations to the organizers for pulling this together, and it's great to see so many people have come out. I actually had a presentation prepared, slide deck and stuff, to talk about IP and copyright, but about an hour before this panel I decided to drop it and talk instead about some of the implications that I see coming out of the news literally over the last couple of days, and especially over the last couple of hours, that at least for now Belgium will not sign CETA, the trade agreement between Canada and the European Union, and think a little bit about the parallels that might have with the TPP, because I think there's actually a fair amount to be learned from what we've seen with respect to the CETA process with what has taken place between Canada and the EU. Now, as some of you or many of you may know, for the moment, the stumbling block or the barrier to formally signing, as was expected this week, the CETA agreement is a regional government in Belgium, Wallonia, and they're holding out, and because they're holding out, Belgium is unable to sign, and because Belgium is unable to sign, there will be, at least for the moment, no signing. Full consensus is required, and so that's creating the large barrier or the stumbling block, or at least that's how it will be described. I think over the coming days and certainly over the weekend, we heard and will continue to hear a lot about Wallonia being an outlier. We were talking about it earlier, and the notion that somehow pressure will be brought to bear on this regional government such that they must ultimately sign on. I'd argue that this in some ways provides us a bit of a preview of what happens here in Canada should the government follow through on what it says is a true open consultation and ultimately perhaps arrives at the decision that notwithstanding the fact that it signed the TPP, it doesn't want to move forward. In other words, we might be Wallonia. We might be the country within the TPP that everybody says you must agree. We wouldn't have the ability to hold up the TPP. That power is reserved for the United States and Japan. But nevertheless, we might find ourselves painted as the outlier in all of this, somehow being anti-trade, not following through, and being told, kind of just get on with it, everybody else agrees, and so must you. I think that we have to take a more careful look at what's taking place in Europe, because what I think is taking place in Europe is not per se anti-trade, and doesn't represent a single outlier either. Indeed, the opposition that we've seen over the last weeks really isn't just opposition that's taken place in Europe over the last weeks. If you go back now months, while Canadians weren't really thinking all much about this, and while our international trade minister, who I have a great deal of admiration for, Krista Freeland, talks about how nice Canadians are, why won't you all just agree with us on this? The reality of this is that there have been thousands that have taken to the streets in Europe now for months over this particular agreement, expressing real and I would argue legitimate concerns. And the kinds of concerns that they have been raising in the context of CETA are very often the same kinds of concerns that we see raised within the context of the TPP. I think it would be a mistake to think this is simply about recalcitrant holdout or people who are just anti-trade. I think it's about much more than that. I'd focus on two things in particular. In fact, Professor Van Duzer, in a sense, highlighted it a little bit when he said, as we talk about the TPP, it's not just a big trade agreement, it's actually an agreement that covers a wide range of other issues, such as intellectual property. And therein, I think, in many respects, lies the nub. This isn't just a trade agreement. And so for those that argue that they're just trade agreements anyway, we've already signed a bunch of these, are you really against lowering tariff barriers? Miss the point that these agreements long ago in some respects shifted away from merely being about the reduction of tariff barriers and moved instead into a range of areas in the sense that these become regulatory agreements, and in many instances regulatory agreements that leave the domestic countries with little choice but to change their laws, and in some instances as well adopt rules such as the investor-state dispute settlement systems. That is why, not because that is why we see opposition to this, not because people object to the prospect of cheaper prices for agricultural products or some of the other kinds of things that are included within both the TPP and CETA. And so why do we see those concerns? Two things in particular I wanted to focus on. The first, and there is a commonality here between both CETA and TPP as well as other earlier agreements such as the Anti-Counterfeiting Trade Agreement, ACTA, and that is the lack of transparency associated with these agreements. By and large, we're told that the way that you have to negotiate these sorts of trade agreements is to have them done largely in secret, and we'll present you with the text at the very end of the day. Now there's a problem with that, because if you argue on the one hand that trade agreements, at least the old style trade agreements that involved that give and take, had to be negotiated in secret, I can perhaps accept some of that. But what I don't think is right is that the kinds of issues that we find within the TPP as well as within CETA, things like environmental standards or intellectual property rights, those are the sorts of issues that were not in the past on a global basis negotiated in secret. I mean, we see that all the time, whether it's with the Paris Agreement or WIPO negotiations in Geneva. We see active access to texts as these are being negotiated, clear positions that are articulated by various countries, the ability for NGOs to comment, indeed the ability for the public to actively participate in the development and negotiations of these kinds of agreements. What happens with agreements like the TPP is that those issues are then taken off the public table, negotiated in private, and the public is told you'll have the opportunity to discuss this and see the text at the end of the day. But as we often learn, at the end of the day, once that text is made available, it's simply too late. I appeared already a number of times now, I've appeared a number of times before parliamentary committees on this issue. And I recall early on appearing, commenting on some of the leaked texts that had been come out on the TPP, and was told by government MPs, at the time that then it was a conservative government MPs, we don't comment on leaks. You'll have an opportunity to talk about this once the text is made readily available. Well, once I went back to that committee after the text was readily available a number of months ago, in some ways those same conservative MPs now said, why are we continuing to consult on this? There's no need to talk anymore about it. The text is there. Let's just go ahead and get on with the process. And so in a sense, that kind of secrecy, I think, really undermines public confidence in these agreements and ultimately leaves us without the ability to craft these kinds of social policies and in many instances public policies with actual public involvement. Which brings me to the second part of this, again, is to emphasize that this is not just a trade agreement. On things like investor-state dispute settlement, which has been at the heart of some of the kinds of concerns, of all countries, Canada has real-world experience about why this is not just unnecessary, but can be incredibly costly. Cases like the Bill Con case here in Canada, as well as the ongoing case involving Eli Lilly, points out that there is the prospect of hundreds of millions in liability, as well as these tribunals ruling against environmental rules here at home. Now, ISDS rules largely came out of the sense that if you had investment agreements with certain countries where the courts themselves couldn't be counted on, or there was a lack of investor confidence in what the court outcomes might be, you needed a system to ensure that investors would still invest, and ISDS was designed to provide that investor confidence. And yet, in agreements like the TPP, and certainly like in agreements like CETA, the notion that there isn't confidence, let's say, in the Canadian courts or in the European courts or the US courts or the Australian courts, simply isn't there. This is a non-issue in terms of inspiring investor confidence. And the idea that we would provide more powers to foreign investors, more than even Canadian companies would enjoy in their own jurisdiction, simply doesn't make any sort of policy sense, and as we have learned from our own experience, raises real risks. Now finally, because I know I've got to go quick, there is the whole series of regulations that raise a wide range of issues. There's the patent issues, and I know we'll hear a bit more about that today, and I think there is an important linkage there between CETA and TPP, because CETA was designed to provide cover for the TPP on a number of these patent issues. And so when the government talked about the changes that would be required for patents within the TPP, they downplayed, by and large, many of those changes, in part because they argued we're already doing it as part of CETA. Well, it turns out we may not be doing it as part of CETA, which means that it would be TPP that would be requiring those changes. But it's not just patents that we'll hear about, it's copyright as well, things like copyright term extension that will increase decrease access to the public domain, ultimately increasing our costs, as well as a whole range of other issues. Privacy is included in the TPP, and privacy has been one of the issues that has been raised by people in Europe as a source of concern with respect to CETA. Indeed, even culture is included within this. We've got the Heritage Minister right now running around talking about digital CanCon and the prospect of new rules to help support the Canadian system, and buried within the TPP in an annex are provisions that actually create restrictions on what Canada can do to support its own Canadian content. In some instances, there are certain things we simply can't do as part of this process. Now, we can debate whether or not the kinds of things the TPP proposes to stop are good or bad, but the notion that somehow it would be the TPP that would decide those kinds of things. Again, an agreement negotiated in secret with provisions buried in an annex I would argue is quite clear. There's just no reason to be embedding that kind of policy within this kind of trade agreement. So as we follow the news and the headlines and the kind of reverberations from what literally just happened in the last couple of hours, as the Belgian Prime Minister said they will not sign, let's bear in mind that in some respects we're seeing the prospect of a bit of a trial run for the TPP when, after the US election, and it becomes clear whether or not this is going to become anything at all, various countries ultimately decide, including our own, whether or not to move forward, and we run the risk of being labeled in the same way that Wallonia is being labeled some sort of outlier holdout, as opposed to a jurisdiction that more carefully looks at the fine print of the agreement and says something that, and perhaps reaches the conclusion that the costs of the agreement outweigh the benefits.
Well, everyone, it's a real pleasure for me to be here. It's just if I can have access. Okay, fantastic. And no, it's not my presentation. Let's go back. Oh, on the desktop. Perfect. Here it is. What I'm gonna first, thanks a lot to the Center for organizing this, to Gallo as well, and Universities Allied for Essential Medicines. I'm going to be talking CETA and TPP impact on the Canadian pharmaceutical sector. So I'm not looking at other countries, but really what's happening for Canada. So two things. First, some facts and figures about the Canadian context and the dominant narrative we find in place here. And then looking more closely what CETA and TPP would mean in terms of impact in the Canadian pharmaceutical sector. So in terms of fact and figure, if you look at per capita cost on prescription drugs in Canada, basically we spend 50% more than the OECD average. But at the same time, we're still doing a very crappy job in terms of providing good access to all Canadians in terms of drugs compared to other countries with universal access. Now, one of the reasons behind this is because we pay higher prices for patented drugs. So Canada, we're third here. And a median OECD, it's 78% of the prices we find in Canada. There's big issues in terms of additional confidential rebates. We're doing a very lousy job in terms of negotiating these rebates right now. So basically, even if you include these rebates in Canada, right now would be something at 98 as compared to 100, still much higher than the other countries that do a much better job in negotiating these additional confidential rebates. So in fact, now we have the smallest discrepancy between the two prices. In reality, it's a bit larger than that, but it's confidential. We don't have access to these data. Now, one of the reasons why we're paying more for the price of the same drugs in Canada, it's because we have a very lax system in terms of pricing regulations for patented drugs. And basically it was put in place end of the 1980s. So there was the discussion in terms of changing the Patent Act, so under the Conservatives. So, okay, let's provide more intellectual property protection for drug companies, but in return, what we demand to the drug companies, it's more investment in terms of research and development. So really thinking about this, not in terms of access to medicines, but really in terms of industrial policy to have more investment. That's one thing. So in terms of regulations capping the price of patented drugs, we decided to remain very lax. The idea is with higher prices, we will create this more business-friendly environment for investment, so we will become this powerhouse of research and development. So the magic number at the time was 10%. Basically 10%, that was the agreement between the drug companies and the Canadian government. So, okay, we're giving you this privilege, well, this increased patent protection, but in return we want drug companies to spend 10% of their Canadian sales into Canadian research and development. And you know, at first what we see in 1988, so the agreement was with the RX and D patentees at the time, massive increase of this R&D to sales ratio, so massive increase in research and development investment in Canada. But over time, basically, we kind of forgot about this agreement. and huge decline, especially since mid 2000. In Quebec, for example, we lost half of the employment. The pharmaceutical sector, major research lab closed down, and in fact, right now, this R&D to sales ratio is lower than what it was before we changed the Patent Act in 1987-88. So if we see ourselves as this major powerhouse in terms of research and development, well, we're behind Romania, Cyprus, and Croatia, for example. But the thing is, we have a dominant narrative in Canada that, okay, if we increase the revenues of drug companies in Canada, by some type of magic, the investment in research and development will start growing at the same rate, basically. So if we compare ourselves to other countries with high prices, we will also get high research and development. This is not happening. In the last 3 years, the Patent and Medicines Price Review Board has been writing textually in their annual report, this is not happening. Our mandate is based on this bogus idea that increasing prices also increase R&D investment. It's not happening. There's no evidence nowhere that it says it could be an issue. Still, because of this massive decline in research and development investment in Canada in recent years, answer of the Conservative government was, well, with CETA, let's try to increase even more patent protection, so then more revenues for Canadian drug companies, and magically maybe R&D investment will start growing again. But so let's say that this dominant narrative is based on nothing. So just give you an idea, since 1988, Canada has offered generous prices to attract R&D investment. If price levels for patented drugs in Canada were similar to France or the UK, for example, Canada, we're spending 19 billion a year on patented drugs. So right now, would be saving 2.9 billion a year on patented drugs. Now, total R&D investment in Canada was 739 million in 2014, half of which was recouped through tax credits. That's the way to provide incentives for R&D, tax credits. So basically, the post-1988 regulation system in place make Canadians pay artificially inflated prices by around $3 billion a year in order to generate net R&D expenditures of 370 million a year. So, I mean, there's somebody somewhere that did not do his cost-benefit analysis. Now, looking at CETA and TPP. CETA would have no impact on European pharmaceutical policy, major impact on Canadian pharmaceutical policy when it comes to intellectual property. So there's 3 issues, no need to go into the details. Basically, patent term restoration, we would increase the time of patent protection to recoup the time needed for drug approval, up to 2 years. Data exclusivity would not change what are the current rules in Canada, but it would lock in the current rules in Canada, so 8 years of data exclusivity. And patent linkage, basically we have a complex system. When a generic wants to enter the market, you need to prove that you're not infringing any patent. Now we would give the brand name drug companies a right of appeal if they disagree with the decision of the court that there is no infringement. What we did, now keep in mind that all these changes, CETA and TPP, would not apply to current drugs, would apply to the new drugs arriving on the market once the agreement is signed. So it will, the full impact in terms of cost cannot be seen before 8-9 years. But what we did is we used a sample of all the drugs in 2010 and we calculated how much it would mean in terms of cost impact for these drugs, looking just in 2010, expansion of market exclusivity, so what it would mean in terms of increased cost. So based on this calculation, if CETA was in full effect in 2010 with the drugs then, it would mean increased cost by 6.2%. There was one issue about data exclusivity that wasn't very clear. Would it be possible to interpret that exclusivity to extend it to non-innovative drugs? It's not supposed to be so, but there was some possibility of this type of interpretation, which could have a massive increase up to 13% on the cost of of patented drugs. Now, CETA, there is no requirement or demands in return. At the time, at least, we asked 10% of Canadian sales should be reinvested in research and development in Canada. Now there's no requirement. This is just a giveaway without without any counterpart. And for me, offering privileges without counterparts is what defines corporate welfare. But, on TPP, TPP is a bit different in many ways. When it comes to intellectual property, way less scary than CETA. Basically, it's really only about patent term restoration, similar to CETA. No issue about the right of appeal. We did the calculation. If we implemented TPP without CETA, so it would not be an increased cost of 6.2%, it would be 5% instead. So it's still very significant. But if CETA is implemented before TPP, basically TPP has no impact on intellectual property in Canada. Chapter 9, so chapter on investment, the investor-state dispute settlement. What is interesting is that what it says is that we have TRIPS, and basically investors would be able to sue states under the ISDS in TPP, which is kind of weird. For Canada, there's no big impact, but for some countries, that could be that could have some potential impact. The fact that we're enforcing TRIPS through ISDS, there is no ISDS right now under TRIPS. Now, when it comes to pharma, you have two annexes, so yes, buried in the annex. One about the technical barriers to trade. Some issues on pharma. First, international harmonization. There's always many issues when it comes to international harmonization. The thing is, still, the language remains very vague. It's mostly about inspection, so coordinating with it, which is a good thing, basically. Coordination with inspection. So for me, this is kind of a good thing that we find in TPP. Marketing authorization in a timely manner. So, trade agreements, it's really about the ratcheting effect, basically. So you have, okay, you're opening doors or windows on possible things. So you start with something, but maybe the next trade agreement will go a bit further. So this one is interesting in terms of the windows that are being opened here. So marketing authorization in a timely manner. So make sure that Health Canada doesn't take too much time to review the evidence before approving the drug. Still, language is so vague in TPP, I don't think it would be a real issue right now. It could be if other trade agreements continue to go further in that direction. Now, something interesting. No party shall require sale data or related financial data concerning the marketing of the product as part of the determination for marketing authorization. Further, each party shall endeavor to not require pricing data as part of the determination. There's many states in the United States right now. What they're putting in place is more transparency in terms of pricing, in terms of R&D costs. There's these weird claims of drug companies. Oh, it's costing us $2.6 billion to arrive with a new drug on the market. But still, 2.6, this is just a claim. There's no calculation, data behind this. So basically, let us see the data. Then the issue is, should we, based, for example, reimbursement decision based on the cost of producing the drug, cost of R&D behind it, the point is disclosing financial data. Could it be a possibility in terms of fixing the price? This is only what we accept to pay for this drug, and if you refuse this price, basically, then we can have a compulsory license. Now, it's not really an issue here because usually drug approval, marketing authorization is done by Health Canada, and reimbursement decisions are done through the Canadian Agencies of Drugs and Technologies of Health. Usually it's separated. In every country, usually the two decisions are separated. Still, it opens a door in terms of, okay, non-disclosure of financial data that basically can be, in the long run, something problematic in terms of transparency, even for reimbursement decision. Finally, there's this Annex 26A part of Transparency and Corruption Annex, so 26A, it's Transparency and Procedural Fairness for Pharmaceutical Products and Medical Devices. Asking for procedural fairness about reimbursement decisions. So if you refuse to reimburse a drug at the price we're asking, well, the state has to, well, or the Canadian agency has to justify in details the reason behind this in a clear and transparent way. This is not too bad. Still, if you can start suing the state based on reimbursement decisions, that would be problematic. Still, Annex 26A says, well, ISDS should not apply to 26A. So, okay, then in that case, we're kind of reassured. Still, we're opening a weird window for the coming trade agreements as well. Now, 26A3, dissemination of online information. I'm almost. Dissemination of online information to consumers. So, okay, drug companies will be allowed to disseminate online information to consumers. What does that mean exactly? Right now, we cannot have direct-to-consumer advertising, for example, when it comes to drug. But you know, in the United States, for example, based on First Amendment, well, if there's this new medical study that just came out that shows some benefits of the product with some off-label use for the product, well, the state should not be allowed to impede or restrain the capacity to communicate this information to physicians. So basically, advertising to physicians for off-label use of the drug is now legal in the United States. Now, would this mean we would allow dissemination of online information for off-label use of drugs in Canada, which would be something very, very problematic in many ways? Well, yes, this is a door that is being opened. No ISDS would apply to 26A here, but still, it means that we're going in some weird direction. So, conclusion, be very careful of the ratcheting effect, especially when it comes to TPP. The doors that are being opened for me are very problematic. Well, it's time to change the narrative in terms of, no, more revenues to drug companies doesn't mean more research and development. You know, sorry, I have to say this. We managed to develop one big pharma company in Canada with all the policies and privileges. It's Valiant. Valiant, the business model, basically, you buy back competitors, you increase the price, and you cut down the cost by closing down the research lab. I mean, you increase the revenues in terms of drug, yes, but you reduce at the same time R&D investments. So this is, for me, something very problematic, but it's still ingrained. We met with the same conservative MPs, I guess. If intellectual property is about making sure that every country is doing their fair share in favor of pharmaceutical innovation, why no discussion of alternatives about how to fund this research and development? There's this idea that we need absolutely to link the R&D cost to the price of the drug. This is, in many ways, pure nonsense, and there's other alternative models, cost-based approach, the Health Impact Fund, or basically what we're spending in public research. There's a big conference coming in 2 weeks in Washington about this idea of delinking R&D costs with prices. We need to find some way to pay for R&D. Let's pay for R&D, but do not link this to having higher prices for specific drugs. Thank you.
Go ahead.
Yes, go ahead.
I'll just go ahead. Okay. Okay, I have some bad news for you, and I have some good news for you. So the bad news is that I was actually under the impression that I had about 25 minutes. The good news is that, in fact, we've actually already published quite a lot about what I'm going to be talking about in open access journals, so it's pretty easy for you to go and sort of see what, in fact, we found in our health impact assessment. I'm going to bypass this slide just to point out that if Japan and the US does not ratify the TPP, there is no TPP. And a lot of concern right now about whether Obama in the lame duck congressional session will try to ram it through Congress. Japan sort of seems to be okay with it, so we may have a TPP, but we may not have a TPP. Now, if we take a look at why we have a TPP, it's quite revealing what the U.S. Trade Representative Office has on its front page around the Trans-Pacifique Partnership Agreement, Made in America. Now, when Joe Stiglitz was here last April presenting on the TPP at a special colloquium, he clarified that. He said it's not made in America, but it's made by American transnational corporations. What seems to be at stake here is that the U.S., in its tilt to Asia, would like to write the trade treaty agreements or investment agreements for the Asia-Pacific region, essentially before China gets a chance to. So we really have basically kind of a bipolar power struggles going on here. Now, when we undertook our health impact assessment, we looked at health systems, we looked at the IP issues and pharmaceuticals. That's usually where attention first goes in terms of health impacts. But we're also concerned about increased trade in health harmful commodities, tobacco, alcohol, obesogenic foods, those sorts of things. And then also about how it was going to affect the regulatory policy environment. And then finally, how is it actually going to impact the environment? How is it going to impact employment? Because the dominant argument around these agreements is that it's good for the economy. So very briefly, I'm going to try to touch on 4 different kind of topics. One of them is the right to regulate. And if we look at the right to regulate in relationship to health services, Canada here, actually, we largely shielded our right to regulate in health services in a particular kind of annex to the agreement. And we did the same thing when we committed under the GATS agreement in terms of trade and health services. But we did not include in either of those private health insurance, because that was part of the financial kind of market or financial services sector. So should Canada, if we wanted to extend our single payer system to areas which are presently privately insured, and which presently have foreign investors involved in that private insurance market, so that could be dental care, extended care, coverage for pharmaceuticals, that if we decided to extend a monopoly in that area, we could be exposed to an investor-state dispute settlement challenge. So we're not completely or fully protected, largely but not completely. But a big issue is really about concern about health harmful commodities. Now, that's not really a concern for countries like Canada, the US, or Australia, or other high-income countries that are part of the TPP, because frankly, we've already lost that battle, and we're sort of trying to recoup in terms of pulling back now, as Jane Philpott today is going to announce new regulations around marketing of unhealthy foods to children. But in countries like Vietnam, it's quite a different story. Vietnam, for example, right now, only 1.4% of women smoke. And the tobacco transnationals are dying to get in there. We have a kind of case point in terms of when South Korea opened its market to tobacco transnationals. Women only had a smoking rate of 1.8%. Now it's 18% since the market opened. So there's a lot of concern there, plus concern in terms of the obesogenic food environment. Vietnam just recently got its first McDonald's. Within the space of a couple of years, it's now got 8 chains. So that's a concern that we have there. We actually looked at that in relationship as another part of our study on TPP. It's not directly related to the trade agreement itself, but we looked at what happened when Vietnam, as a very late accession to the WTO, and in terms of opening up its financial markets under liberalization, what happened to the sugar-sweetened carbonated beverages, the soda things now that we're trying to put taxes on to slow down the consumption? Coca-Cola and Pepsi-Cola massively increased their shares in that country, and there was a huge spike in consumption in Vietnam compared to the Philippines, which is a country that had opened itself up much earlier on. So there was no big spike in the Philippines. So we can expect to see some long-term health consequences of that in Vietnam. Generally speaking, in terms of looking at the right to regulate, there are several aspects of regulation with indirect kind of health or direct health implications that are part of the TPP. And there are 3 chapters that we were really mostly concerned with. One of the chapters is on regulatory coherence. Now that's a brand new chapter. It's previously not been in any trade agreement. It's largely rhetorical. It's a shopping list of good intentions, but doesn't really impose a huge burden in terms of the regulatory space for countries, except for the fact that it basically calls on all country members of the TPP to open themselves up to interested parties of every other TPP country. And by interested parties, that also includes the private sector and transnational corporations, to involve themselves in the regulatory policy setting of a TPP country. So Canada would have to open itself up to transnationals in any other TPP country when we wanted to basically establish a new public health regulation. One of the problems we have is that we take a look at the sanitary and phytosanitary standards chapter. Now, this problem goes all the way back to the WTO, where the reference back to international standards, and the reference point that's usually used are the standards that are set by the Codex, the kind of joint undertaking of the WHO and the Food and Agricultural Organization, but very heavily dominated by corporate scientists. Now, when Codex first kind of came onto the scene, it was basically saying, this is the minimum standard that you must have. And you can have any other standard you want above that. When the WTO wrote reference to the Codex into the SBS agreement, it basically said you can have that a standard and you can go above it, but only if you actually have scientific justification. So it switched the floor on regulation to become the ceiling on regulation. And the TPP makes this a little worse here, because although the WTO does sort of say there has to be scientific justification, it actually allows for a minority scientific justification. So if there's any kind of minority scientific opinion, you don't have to have absolute definitive kind of consensus on what the risks are. Plus, you can establish a regulation first, and then it's up to a state to dispute that and go through the formal dispute settlement process. The SPS ups the ante on that in the Trans-Pacific Partnership Agreement by basically saying countries have to ensure that their new regulation is compliant with these international standards before they put them in place. Plus, it sort of says that they have to be based on documented and objective scientific evidence. So it raises the bar in terms of the level of scientific evidence required. And a lot of us are concerned that this actually undermines any exercise of the precautionary principle, and the fact that many of the public health risks that we're going to face now are ones that we actually don't have that kind of definitive or consensus scientific opinion on. Now, we see the same thing kind of happening with the technical barriers to trade agreement. The TBT itself under the WTO is a bit of a tough haul in terms of having to go through all these rounds of necessity tests. But under the TPP, we have another one here which has said, once again, that they have to ensure there's no unnecessary interference with trade before the regulation is put in place. So we're getting this antecedent effect. Plus, it restates what the SBS says, is that it allows them to participate in the development of all such regulations, or restates what's in the regulatory coherence. Okay, the big issue, which you've already heard a little bit about, is ISDS. And I have to thank Gus Van Harten for these slides, which he presented at the April colloquium. And basically what it says is that, I mean, it took a long time for the evolution of little bilateral investment treaties to become these regional trade agreements with these massive sort of ISDS sorts of claims. And as these claims, number of claims increased, so did the value of the awards that these tribunal arbitrators made against governments. And as Gus likes to point out, the second largest beneficiary of these ISDS disputes is in fact the legal industry that's busily promoting ISDS to the corporations as a way of basically getting revenue and basically trying to stop regulatory enhancements. Now, governments can never win. They can only not lose. And we had the rather kind of unexpected outcome with the El Salvador case against Oceanic Gold, where the ICSID finally actually ruled and sort of said, well, guess what? El Salvador is right. But in the process, so they don't have to pay the $250 or $300 million claim that Oceanic Gold was making, because it was denied a permit to actually open a mine that was going to destroy and pollute one of the major waterways in the country. But it did cost $12 million in legal fees, which someone estimated is the equivalent of being able to have adult literacy for 140,000 people in El Salvador for 2 years. So there are costs, even when governments, quote, do not lose. Now, in terms of public health, and this is something that's already been mentioned, is that one of the reasons or concerns here is that most of the disputes have been around in environmental and land use issues, which indirectly have very important health effects in terms of the risks of pollution. Now, governments are very keen to try to assure us around the TPP that they have the right to regulate. And this, when you take a look at this little section out of the chapter on ISDS, it looks pretty good until you actually just take a look at these kind of like 5 italicized words, which essentially says that governments can regulate all they want, provided they're in complete compliance with all the terms of this agreement. So it's kind of like, it sort of says, oh, you can do this, but only if you actually do all of this as well. Okay, we do have a little more protection in one of the annexes here in terms of indirect expropriation, but the little phrase, except in rare circumstances, still provides wiggle room to the investment lawyers in the tribunals. Now, a lot is made about tobacco control and the carve-out or supposed exemption of tobacco control from ISDS in the TPP. And that's fine as far as it goes. But it's not a full carve-out because it still allows state-to-state disputes to arise. They're probably less a concern now than the ISDS disputes. But you kind of wonder that if they can do that for tobacco, why could they not do that for every internationally agreed upon public health regulation or a best buy policy that the World Health Assembly comes up with? Why just restrict it to tobacco? Now let's very briefly talk about the economic claims, because the underpinning all of this is the argument that this is really important for the Canadian economy or for the economies of the TPP countries. Just a global background picture. Since our era of trade and investment liberalization took off in the 1980s, the total value going to labor, the real economy of global economic product, has nosedived. Right? So labor isn't going to get a lot out of this particular agreement. They haven't so far in the last 40 years. Why would we expect that they're going to do so with the TPP? So we hear the TPP being referred to as this gold-plated treaty with huge economic opportunities. Well, of the 7 econometric studies that we looked at, the most optimistic one shows only modest gains for all TPP countries, and that's an average of 0.5% by 2025. And some economists describe this as really just rounding errors. But what's really quite compelling about this is that all of these models use something called computable general equilibrium, and it assumes full employment, so no changes to the number of people employed, equal or improving income gains, and no costs, 0, no cost whatsoever. And to which that's kind of like a bit like the magical thinking that I think, was it Michael, or you were talking about, Marc André? And the chief economist for GAC here in Canada recently estimates that it would be a 0.127% tick-up in GDP for Canada by 2040, increasing our GDP by $4.3 billion. Now, that's a long time to wait for 1/10 of 1% increase in GDP. Now, alternative models here actually sort of have come up and without making those sort of assumptions that are in the CGE, and basically indicate that amongst the high-income countries there's going to be a net drop averaged across the countries in GDP. Negligible gains for developing countries, and a net loss in employment across all 12 countries. And in Canada, that figure is 58,000. And the only study that actually looked at income effects comes out of the United States and basically found that for most people in the United States, they're going to see a drop in their income, except for that indomitable and veritable 1%. Now, because of the time, I'll just very briefly summarize about the fact that a lot is made about the TPP, the fact that it's got a labor chapter and an environment chapter. Now, the environment chapter is full of hortatory language, a lot of kind of aspirational talk that's not enforceable. The one part that is enforceable is something we did about overfishing, subsidies for overfishing when the fish stock is in a critical shape. Now that's fine, that's good, that's an interesting kind of little twist in that chapter. But if it could do that for overfishing, why could it not do that for fossil fuel subsidies, which right now amount to $2.9 trillion a year amongst various countries? And especially given that the Paris Accord on climate change is completely silent on the issue of trade. And when we come to the issue of labor, the only concern in the chapter with labor is that countries do not lower their own labor standards. So it says countries can set their own labor standards. And they can't lower those labor standards in order to get a trade advantage. So it doesn't really say about what the quality of those labor regulations or labor standards should be, only that they shouldn't use low labor standards after they sign or ratify the agreement to actually get a trade advantage. And every single agreement so far that's had a labor chapter in it has never, ever led to a dispute. So basically these two chapters are essentially window dressing. And that led us to basically conclude, given all of the kind of risks or costs that are implicit in something like the TPP, if the 12 countries, unless they agree to reopen the agreement, the best option that countries should take is just say no. Because what we really need to be doing now is looking at what kind of agreements do we need for international trade that meet the challenges of the 21st century, especially in light of the new Sustainable Development Goals. So thank you, and I'm going to give you a short list here of, in fact, a longer list of acknowledgments, because a lot of people were involved in putting this together.
Well, thank you to all the members of the panel, and thank you, well, except for Ron, for keeping within time, and I apologize if you got incorrect information on the time that we have. But we do have, fortunately, a few minutes left for questions from the floor. So I'm going to open it up to the floor, and if you could just put your hand and identify yourself. Well, I'll recognize you, and then if you could identify yourself and ask your question, please. So, questions from the room. Yes, at the back there.
This question for any panelist, although it is following up on Professor Levante's presentation, particularly on the ISDS tobacco carve-out in the TPP, which, as of within the last week, we've now seen, even if the TPP dies, that idea is now materializing in other agreements. And of course, at least some of the impetus was this whole, trademark expropriation, plain packaging, and so on. So I'm wondering if there are any thoughts on, is this going to keep any of these issues very much compartmentalized for tobacco, or are some of these ideas going to spill over, ideas like expropriating trademarks by having plain packaging for, soda or something like that? Are we, which direction are we headed here?
Ron, just before you answer that, if I could just, I think what we might do in the interest of trying to get as many questions out there is maybe we'll take, say, 3 questions from the floor, and then I'll let the panel respond. And if I could just ask you to be as brief as possible, just in the interest of allowing the maximum participation. So other questions from the room? Yes, over here.
This is probably primarily for Professor Geist, but we're seeing all of these issues, but once we sign, where do we go? Like, how are we able to address the concerns once it's already implemented?
Okay, thank you. We'll take one more. Yes.
I'm Natalie Brender with Genome Canada. A question for Professor Geist and Gagnon. You both talked about, or alluded to, having presented before Conservative and other MPs on this issue of magical thinking with respect to the impacts of a deal on pharma sector. Given that evidence-based policy making is such a big deal these days, do you have any thoughts to offer on what impact pointing out this kind of magical thinking does or does not have on MPs' views, and how it might be made more convincing if it's not currently?
Okay, thank you. Perhaps Ron, you want to start with the response?
Sure. I think that the tobacco exceptionalism will persist for a while. It'll be interesting to sort of see if the TPP actually is ratified, And if Health Canada goes forward with its plain packaging legislation and goes forward with some of the front of the kind of carton sort of food labeling that's going to be tabled today, whether or not that actually starts to trigger any kind of disputes, that's still, I guess, going to be seen. In terms of the plain packaging, I think most people in the public health, the global public health kind of area working on this stuff, and I do a lot of tobacco and trade work in Africa, is of the opinion that this is a norm cascade, and that basically the writing's on the wall in terms of the tobacco transnationals. It doesn't mean that they won't try to pick off smaller, weaker countries, but there's a sense that this is the barn door's open, the horses have already left, it's too late to try to shut it again.
Michael, do you have a?
Sure. So there were a couple issues raised. First off, this issue of signing, I guess, versus ratifying. And in the CETA context, it's particularly confusing because the Conservatives held multiple sort of, they never signed anything. They held sort of multiple events that would have suggested that somehow there was a text and an agreement when in fact there wasn't. And this proposed signing this week was actually going to be the signing of the text, although, as I say, that's not going to happen now. In the context of the TPP, we did sign, but I thought the Canadian government was very careful about making clear that signing was not the same as ratifying. And in fact, just because you have signed something doesn't obligate you to ratify it, and there are agreements that countries have signed that continue to go unratified. An example that often gets raised is the International Convention on Rights of the Child, which I believe the only two countries that haven't ratified are Somalia and the United States. So that there are agreements out there that you sign but you don't necessarily ratify, so we're not under any sort of obligation at this stage to do anything other, given the fact that we've signed. The issue of, in a sense, does any of this matter at all when you're talking to MPs? I will say, at a minimum, in the current environment over the last year, the government is much more open, the current government is much more open at least to listening, and I think has been careful about taking strong positions. I do feel that that the consultation isn't purely theater, and certainly the International Trade Minister Freeland and her Parliamentary Secretary, David Lametti, who's a McGill professor in IP on leave right now, I think are sensitive to some of to the issues that are being raised, at least certainly if you look at their writings before they became politicians. And I genuinely do think that that they're sensitive and actually want to hear this. I suppose at the end of the day, though, there is a real politique that will come forward, right? And so if the U.S., for whatever reason, does move forward, perhaps in the lame duck session, or perhaps President Clinton decides that no wasn't really no, then we'll face an enormous amount of pressure, notwithstanding the data that you've presented, to sign. And I'm not sure that I can't say that I'm particularly confident that whatever evidence gets put forward will be sufficient to overcome the pressure of our largest trading partner saying, we signed and this is going forward, you need to be in or out and you better be in.
Maybe for the third question, I was working with a journalist, and when we demanded the Department of International Trade in terms of what are your arguments in favor of when it comes to pharmaceuticals and the TPPs, so what do you think on this? Will it increase costs or increase research and development spending? And department sent us a report by the conference board saying, well, yes, it will increase research and development because look at Switzerland. They have more IP and more research and development. And no, it will not increase costs because RxMD says so. So the drug, it's just, in terms of evidence-based policy, it was a very hard time for but still, and I agree with Michael that things in the last year are getting much more interesting and way more open to evidence-based policy making. Still, and I think there's a lot of think tanks, Fraser Institute, Conference Board, Montreal Economic Institute, that sometimes can really have a real impact in terms of the mindset of many MPs out there. And, you know, I think it's, as academics, it's also our job not only to do the evidence-based stuff, doing the research and publishing the research in a scientific journal, but basically it's also our job to raise our voice when policy is not evidence-based, because just publishing things as compared to a communication campaign organized by powerful groups, your impact is nil. So I think academics need to organize a little bit and get their voice heard.
Just
Follow-up, Ron?
yeah, a quick addition to that, which is that I think that the emphasis on evidence-based policy making actually runs the risk of being a sort of magical thinking itself. We know that evidence is only one element in any policy decision making. And when it comes to the parliamentary committee and the hearings over the past year, I have a kind of a little bit more of a cynical interpretation of my experience on that committee, which is that the emphasis, all of the emphasis in the discussion coming from the Conservatives and from, well, the Conservatives were just kind of a bit of a write-off, but even from the Liberal members of that committee, was really to focus on what would the cost be to Canada if we didn't ratify. So the emphasis, even when we did an analysis of the consultation process leading up to Canada joining the TPP in terms of the different kind of private sectors that were engaged, that analysis said that almost all of their concerns were the cost of not participating. So we have an agreement where we're going to sign away all of these different kind of regulatory rights on the basis of what we're afraid to lose, not on the basis of what we're going to gain. Doesn't make any sense to me.
Thanks, Ron. Tamara, did you have anything you wanted to add?
Yeah, I think just following up on that, evidence is just one aspect, and another aspect would be ethics. Ethics would look at what are the actual potential implications on society that this particular trade agreement could have. So there are a number of considerations that should be taken.
Thank you.
I just would like, because I agree, evidence is only one dimension, but you know, should we make smoking illegal? So if you ask a physician, he will say in terms of health issues, yes, absolutely, it should be legal. You talk to a psychiatrist, well, maybe it will help people relieve stress. So you could talk to an economist, no, we should support tobacco because it increased the economy, blah. So these are all evidence from different perspectives, and in the end, yes, you do have a political decision. But if you tell me that we should promote smoking because it's good for your health, well, this is crap, and somebody needs to say no there. And sometimes, with think tanks out there, these are the bogus claims you find on many issues.
Okay, thank you. So we're almost have to cede the room. We've got time for one more question.
I just wanted to ask a little bit about the transparency piece, Marc, and a little bit tied to the ethics question, I guess. So one of the things that the Americans have very much wanted as part of TPP is to hobble government purchasing in pharmaceutical plans, so to be able to restrict their ability to negotiate deep price discounts. And that's what they've been after. But at the same time, Thana, this will not apply, obviously, that won't apply to all the HMOs and the private insurers inside the United States that negotiate these deep discounts, which is the primary modality. And they've, themselves hobbled their own public plans, so they can't negotiate deep prices. This kind of inequity where you're kind of keeping it for yourself, this ability to negotiate these deep discounts, but yet demanding it of other, much often poorer countries, that they be restricted from doing this. So that's one thing. But then the other thing I wonder about is this requirement for transparency. And I get a bit concerned when I hear folks who I think should know better actually thinking this is a good idea. Because I think they think this is some way to punish the drug companies being transparent. But what it does is actually hobble the government purchaser from negotiating tough commercial deals with these so what's his face in Dalhousie kind of calls for this transparency stuff. Mike heard it. These guys, I'm just like, they always, what are they thinking? So anyway, what is he thinking?
Just add, panel undoubtedly has some responses to that. I would say we are supposed to be out of the room by now, so I'd ask you to be quite brief in responding to Professor Flood's question.
In terms of transparency, I mean, yes, absolutely. I was mentioning these confidential agreements. There's a lot of things we don't know about these confidential agreements. And some of the mechanism, for example, okay, if you give me a good price for this drug, for example, for a reference drug for a huge therapeutic category, then I will accept this other drug over the. But all this being confidential, yes. In the long run, it can be something very problematic in terms of allowing this capacity to negotiate down prices. Still, in this 26A right now, it's not subject to ISDS, so the all enforcement dimension is absolutely reduced. But yes, I'm scared in terms of what is the type of door we're opening and what will come out of that in subsequent trade agreements.
Goodbye.
Okay, very good. All right, well, thank you everyone for coming, and thank you to our panel. I think they all did an exemplary job.